The first thing you need to grasp when understanding the function of the European Conventions Court is that it's primarily a smoother of issues, and it doesn't prefer taking any positions that might, demonstrate a side being taken. What do I mean by this? Well, the first things you need to look at is what are the options of what a court could become. Either cooperative or controversial. ECHR is a cooperative court, meaning it operates in a way which is more diplomatic than anything else. At least when you look at the term or at the criteria of a court. It's still important to remember they are primarily judges, right? But their judging is very, first of all, unique and profound at its time, considering the fact that it's built on treaties, which doesn't really work unless everyone does it together. That's why you would say they are, first of all, a smoother of rights, and they work cooperatively to find concentration in the issue at hand, okay? To concentrate what has happened, how it is interpreted through the convention, and so on. However, interpretation is not something that the court likes to do. By interpretation, I mean actually trying to figure out the facts of the matter. Now, I should add, there are cases where the court does like to interpret what actually happened in a case. I am not sure which article it is, if anyone could comment which one it is, but I do know there is a specific article which, whenever it is placed in a court, the court likes to investigate more within their own interpretations being made, rather than assuming that the country which is being put into question having the right information gathered. This is very important, okay? Most courts usually don't ask the question of if something which has been established actually is sound. By this, I mean, from a Swedish perspective, if you work your way up in courts, from the most regular court to the Supreme Court, usually one of the hardest things that you can do is actually arguing the matter of the fact, arguing what actually was found in the circumstances of the case. What you actually do argue is, for instance, the way in which those interpretations were applied and the way they were taken into account through law. So, now that we've gone through this, that was just a quick sort of side thought. But it's not primarily a thing within the European court. If anyone's Swedish and watching this, do note that within den inhemska domstolen. Anyway, going on. Margin of error, or in Swedish known as bedömningsmarginal. It's pretty much the convention's way of bringing in a principle. So you could call it the principle of margin of error, where each country has a margin of their own right to error according to the convention. So you could call margin of error as a principle of conform application, okay? Conformity. Meaning each country has their own respective right of looking at how something could be handled, okay? And each of these questions are within their own scope of rights, so long as you look at the national history, you look at the precedents that have been set by that nation, but you can also look at how other nations have taken their own rights of applying margin of errors to, as your own nation, look at how you can do it yourself. Now, an example of this could be, for instance, what is a good example of when margin of error? Oh yeah, there was a case, I can't remember the exact case law, but it was a man who wrote a book with some controversial things inside of it. It was a children's book, and the UK decided that his book was too weird and was too controversial to actually be legally published for children and be put into schools, mostly because it had it spoke about issues of homosexuality and sexual trying out things and stuff. It was very, very suggestive. That's what I've heard, at least. I had a few classmates that actually read the book and told me that it was pretty weird. But yeah, the issue was that Denmark had actually allowed this book to be published, and the court had the person who had written the book argue to the UK that you can't ban my book if it was allowed in this other country with the same conventions followed. And the court said pretty much that this is a question of margin of error, where the UK withholds its right to interpret this book as either okay or not okay for its own respective nation, with its own nationality, history, culture, and so on. So that's the most important thing you need to know about margin of error. It's sort of a way of being able to pursue this cooperative, concentrated investigation of cases that are being brought to the convention, okay? They use the margin of error to ensure that nothing is controversial and nothing is interpretative, okay? It's purely based on the things that are at hand, the things that we can actually look into, and the court is just using things that were available before and making them into something practical, okay? So this is very important. The European Convention does not like, as a court, to do anything that hasn't been done before within its own scope of right. It's good to know. Now, going on, state of the ECHR's case laws. This is important because, for instance, with the EU, also within Sweden, case laws usually set precedents, prejudicat, which successively creates more and more case laws which can define different rights, okay? This is usually the case of how courts function. They are supposed to fill in the gaps or to supplement the law within individual cases. However, ECHR doesn't really function that way. That's why I said before it's more unique and it's profound from its time, because it doesn't actually work that way. Each case has different ideas of how that country or that situation should be handled. Like I mentioned before about the margin of error, you can't just directly go into the case laws and find a thread. It's going to be messy, it's going to be everywhere, and I can guarantee you the last thing you should call it is systematic. It is just there, it is available, it is not useless, but it certainly isn't a guaranteed useful tool. And this is just a, consequence of the things that I brought up before. So you shouldn't think of it too much. Moving on, travaux, préparatoires, I think that's how you pronounce it in French, which means documents or work administration being done in preparation of a law being made. In Sweden, we call this förarbeten. I know that in other countries, it can depend upon if things that have been done before a law being made actually matters, but I know that in Sweden, it's essential. It's pretty much impossible to actually understand Swedish just by reading the law book. Like literally, you would be looking like an idiot if you actually listened to the things that it said there, if you didn't look at the travaux préparatoires of Swedish law, okay? Of the förarbeten. This is not the case in the European Convention, okay? It's kind of useless. Except for in the case which I just gave you, in Sigurd Josson v. Iceland, it wasn't useless. It was used to make a decision at the end. I just gave it here as an example if you want to look at a case where they actually did use it, but it's kind of useless. Especially if you're Swedish and watching this, it's super useless compared to how much we value it in Swedish law. And then if you're looking at it from an EU perspective, the EU falls sort of in between, if you ask me. They're not as into it as Sweden, but they are much more into it than the European Convention. I know this because I've read some of its travaux préparatoires in GDPR, and it was pretty important. Like I know that there were some steps from a regulation which I wouldn't have understood without looking at the travaux préparatoires, specifically about sort of how you define things, which the GDPR already has an Article 5, which defines... No, Article 4, I think. Article 5 is principles. So they already have within the superficial parts of the regulation, parts about things that are most important, but even the EU holds its secrets through work that was done before the law was actually implemented. So yeah, but you should know within the European Convention, especially in the first year of being a student, it's not going to matter. I know personally I never used it. Then, going on, analogous rulings. Analogous thinking is just using a sentence, a description, and looking at it more more through implication and through logic, rather than actually looking at the words themselves and what they're saying directly. This is, you could say, the difference of looking at something superficially and then looking at something consequentially. Okay? Should you look at something superficially, in the case of Golder v UK, then Article 6, the right to a fair trial, would not guarantee someone that they always are heard in their wanting to be ruled through a question. In this case, Golder had been unfairly treated, he considered, by the prison system because he had been accused of abusing a guard. The whole thing went down, but then his registration still had things about that, and it was limiting his ability to do certain things. I think it was finding a job, but other things too. The court pretty much said, no, we're not going to look at this. This isn't valid. And then the ECHR said, that's not okay. You can't do that, because if that were the case, then any court could say, we're not going to look into this because we don't think you're valid. So they had to make an analogous ruling, meaning they had to look outside of the words themselves and more look at the implication, the logistics of it, the consequences which it needs to have to actually work. Yes. And then last thing, usage of European nations principles in case law. It's uncommon but important. This just goes back to margin of error. Usually you have this when trying to understand a case. So let's say if I'm going to look at something where, let's say Germany thinks one thing, then maybe I need to look at the principles of Sweden, Spain, and so on to sort of understand the ways which the court complies to different nations, and also the way in which other nations use principles to apply the same issues. Yes, this is pretty much it. The most important thing you should know about this is that the European courts, or the European conventional courts, are there primarily to become a sort of diplomatic court for human rights. And I should add, a lot of people before this was made, like a few years before it was made, thought it wasn't going to work, that they thought it was unrealistic. I'd say those people that had those thoughts, their critiques were valid. And I believe that the same reasons in which they said that it didn't work is the same reason today in which the convention is extremely complex, especially for someone who doesn't have the right of having it explained to them in a very simple manner, which is they are diplomats within court rulings. That's what I would say, at least. Now, is that actually sound within doctrine? Probably not. But it is sound within logic, if you ask me, because they aren't that aggressive compared to, let's say, the EU, which I think it's a lot more fun to read about the EU because the EU court is pretty cocky. The European Convention could never exist whilst also being cocky. Thank you.